Hi everyone. So it has been 100 days since the Trump administration took over, and whoa, we have had so much immigration things happening that I thought we can kind of go over it, right? There's so much going on. There's so much immigration news. There's so much just changing every single day, from executive orders to court trials, all of it. So let's talk about some of the things that has happened, how it can affect your case, and if you are joining me and you have questions, please put them in the comments. I am literally here for you today. So as we're talking about the changes, I will also be answering your questions. So be sure to ask me questions if you're watching this on a replay. Hi, thank you for watching. Also ask me questions, okay? Say hi, ask me questions. Okay? So when people are joining, they know they can ask me questions. All right. So the 100 years. Oh, days. Sorry. I can't believe I said that. It has felt. It has felt, as an immigration lawyer, I can tell you, it has felt like 100 years, but it's only 100 days plus now of the Trump administration, and everyone's talking about, let's look back, let's review, and see how things have changed. So let's do the immigration version of that, right? So, as many of you know, there has been, hi Francisca, there has been so many changes. Hi there. There's been so many changes. There's been so much information overload that I think a lot of people may have kind of stepped back a little bit just for your own mental. Sometimes you have to step back, and as because part of my job is to know everything that's going on with immigration, I don't have that ability to just step back and not know what's going on. So if you are taking some time away from immigration and just coming here to just get the updates and be out, I completely understand because it is a lot. Hi, Carl. Thank you for joining me. It is a lot, okay? It is a lot that's going on, but the more you know, the better you are able to prepare and work within the system. One thing I always say is, I help people get green cards and citizenships using the US immigration law system. I've had to modify that a little bit because the system keeps changing, okay? System keeps changing, and we still have to work within that system. Whatever it looks like, we're still working with it. So the more you know about the changes, the better you're able to work within the system. All right. So let's start with one of the biggest things that happened and everyone freaked out over, which is the birthright citizenship. The executive order basically saying no more birthright citizenship for certain populations of people in the US. So if you are in the US and you're undocumented, the Trump administration wanted to make it so that when you have children, your children are not automatically US citizens. But you know what happened though? There was a lawsuit, which I told people this will happen, right? I did a video last year talking about what may happen, what he can actually get away with, what he's not able to get away with. This is, birthright citizenship is part of the Constitution. It's not just, something that's done by executive order. So if you want to change the US Constitution, there's a process and you need 2/3 of Congress to join you in that. And there's no way that the administration is going to get 2/3 of Congress to say, yes, let's do away with birthright citizenship, especially with the way Congress is set up right now. So what could he do? Executive order. And what happened right after that executive order? There was a lawsuit and there's a pause, right? He cannot use executive order to take away birthright citizenship. That executive order is now at the US Supreme Court. So hopefully before the end of summer, right, depending on how the Supreme Court decides to put out their decisions this year, we should have a final ruling from the Supreme Court about birthright citizenship. If the Supreme Court decides to follow the law, right, and not make up their own law, if they decide to follow U.S. precedent, which says that the constitutional amendments can only be changed through congressional action, right? That is something that the Supreme Court has said for many, many decades. So if they want to change that, it is going to be a huge shift for U.S. legal system as a whole. So we'll find out what happens with that. I'll let you know. But most likely, the Supreme Court is going to side with everyone else and choose to not let the president do that. All right. So that's a good thing that we can hopefully look forward to. The next thing was, all of the ICE actions. A lot of people were detained, were deported, right? Whether they received due process or not, even people that were entitled to due process were not given due process, and people under people from Venezuela were definitely not given due process when they were deported to another country, into a prison system that has been continuously criticized by the US government. Right? So they were put into that prison system. And now, as of this week, a judge just said that the US government cannot use the Alien Enemies Act as a way to deport Venezuelans. Right? So now they have to find another path. The whole point, right? The whole point of this administration, their main thing when it comes to immigration is to deport as many people as possible. And they use that Alien Enemies Act to get so many people out of the US. And now they have to find another tactic. They cannot use that anymore. Because here's the thing, the Alien Enemies Act does not require the US government to give people due process. Every other means of getting people out of the US requires some form of due process. So that's why they went to that, because they're like, we can get rid of as many people as possible before the court is able to stop us. Well, guess what? The court has caught up and stopped them. So now they'll probably take it to the Supreme Court, and we'll see what the Supreme Court has to say about it. But as of now, they are prohibited from deporting anyone under that act. Again, a lot of people were scared about it, and I did say a lot of the executive orders are going to go through court. Okay, as much as the U.S. government, the executive branch has a lot of control, a lot of power when it comes to immigration, right? They have a lot of power. Their power is still checked by the courts, right? There's a check and balances when it comes to US government, right? That's why there's three branches of government that check on each other and make sure that one branch is not overextending their powers, right? Clearly, we can't rely on Congress to put checks on the president because they have the majority. However, we can, it looks like, still rely on the courts to put those checks in place. So that is great. Okay, we will take the wins where we get them. Some other immigration things that happen is a lot of students all of a sudden had their visas revoked, right? Students, they were going to school, they were maintaining their status, had their visas revoked without notice. They just received a letter that says your visa is now revoked. That also went through the courts, and that is also on hold. So I hope you see a theme here. right? There's organizations, there's lawyers out there going to court filing cases. So the one for the students, so F1 students had their visas revoked without any notice, without any means of basically saying, hey, I know you said my visa should be revoked for this reason, but I don't actually fit under that. They did not have any chance at all to keep their visa. So that went through the court, and guess what? The court shut it down. So now the administration reversed that ruling. So now those students have their visas. Again, lawyers out there doing the doing the work, and taking the administration to court. If you are out there, you either you or someone you know are came into the U.S. under a parole, either it's a Haitian, Venezuelan, Cuban parole program, Youth for You program, you know that they received a letter, especially people that came through that final Biden parole program. They received a letter saying that their parole is revoked, and they are most likely going to receive a letter this month saying that their work authorizations have been revoked. Here's the thing with that specific parole. That specific parole was done by executive order. So it can be undone by executive order. All right. So that's why, unfortunately, they can do that. Right. So that's also why, when that parole program came around, we as immigration lawyers were, pushing Congress to actually make that law and not have it just be an executive order, because when it's just an executive order, the next administration can come in and kill it. So, and that's what the Trump administration has done with that. They have come in and killed that executive order, unfortunately, right? Um, so it's really important that as you are hearing like all these new things, you are paying attention to what parts of it can we actually fight. We can't fight the fact that they want to get rid of this parole program. However, what we can fight is them abruptly ending it, right? So if you still had a year left on your parole, can they just say you no longer have that year? That part of it can be fought in court, but the parole itself ending and not being able to be renewed, that's a different situation altogether. So there is a lawsuit going on with that as well. And then to add more to it, if you came in under one of those Biden administration parole programs, or you came in as a refugee, or you received asylum in the US, if you are applying for a green card, they have put a pause on that process. So you came in with parole, or you came in as a refugee, you came in and applied for asylum, your asylum was approved. Now you want to apply for a green card, they are putting a pause on those processes. So they're basically saying an officer may interview you, but they are not able to approve your case. So that's going to cause a huge backlog for those people, because if we don't know, and here's the worst part, right? We don't know when that is going to end. There's no timeline. We are just waiting and seeing what the administration decides to do when they decide to pause that program. So again, these are people that have legal status in the US, right? When you are here under parole, you have status. That parole is a status until it expires. When you have a refugee coming into the US, that refugee status is a status, right? Your asylum is a legal status once it's approved. And US laws says that if you've had asylum and you came in as a refugee and you've been in the US for at least a year, you can apply for a green card. Those people are now applying for a green card and they can't even get a green card because of this pause. So that's something to keep in mind. It is going to cause some backlogs. It is going to increase processing time for a lot of people. And then as far as, the bigger picture of what is it actually going to look like moving forward with immigration, they are going to still keep finding ways to detain people, whether it's legal or not, right? They're going to continue doing that. They're going to continue going after people that help immigrants, right? Um, Apparently, immigration lawyers are obstructing the administration's goal of deporting as many people as possible. And I guess, we are now targeted. Oh, well, right? I'm going to keep doing what I'm doing because, US laws. Until that changes, right? I'll still be doing what I'm doing. But at the end of the day, there is a concerted effort by the administration to scare people. So if you're out there and you are scared, or you're trying to decide whether to stay in the US or if it will be better for you to leave the US and voluntarily self deport, that's the point, right? The whole point is to scare people. That's the whole point. The whole point is to scare lawyers to no longer work with immigrants. It's not really working, but that's the whole point. Okay, so just know that the fear is the point, and it is normal. Okay, I've had people be like, I'm really afraid, but I don't think is it normal to be afraid? It is completely normal. Okay, some days I have a mental breakdown over the craziness of the U.S. immigration system. It's okay. Okay, it's okay, but just know it is normal. All right. Um, the Future Apparel on Instagram is asking, what are the current USCIS processing times realistically? So it depends on the form. Okay, let's start there. It depends on the form that you're filing and what a realistic timeline is. So for citizenship, a realistic timeline is about a year to a year and a half. However, I will tell you, we are seeing a faster timeline for those, but to be on the safest of all safe sides when it comes to having a realistic expectation, it can take up to a year for a citizenship case to go through to the end. And then for adjustment of status based on marriage, we are seeing some quick turnarounds and some very long turnarounds. So it can be right now, we are seeing people scheduled for interviews within 6 months of filing, and we are seeing people scheduled for interviews after a year and a half of filing. Those ones are very specific to the field office that is handling the case. So that's why adjustment of status, I always differentiate that from an I-130. So an I-130 application is typically done at the National Visa Center, National Benefits Center, or at a service center, not a local field office. Okay, so most of the time it's all paperwork unless that service center or the benefit center decides that these people need an interview. Okay, and that's an interview just for the I-130. So unless they decide that, it's all done through paperwork. An officer in the office looks over the application, approves it, and moves on, or denies it and moves on, right? But with an adjustment of status, you're going to have an interview, especially if it's family based. Okay, that's another new policy change, is that all adjustment of status cases based on family is going to get interviews. So we had a lot of interview waivers. We are still getting some interview waivers, but most family based applications are going to be interviewed. So make sure that you are preparing for an interview. Okay, do not assume that you're going to be the 1 out of 10 that gets an interview waiver. No. Assume you're going to get an interview for those adjustment of status, especially based on family. We are saying that adjustment of status can be anywhere from 6 months to a year, sometimes longer, but on average, we're looking at about a year to get that interview. And then once you have the interview, depending on how good or bad the interview went, you may get a decision right away, or if there's any red flags that show up at your interview, you could end up, okay? You could end up in a situation where the officer refers your case to the fraud unit, which they have increased the amount of officers in the fraud units. So before, the fraud units were very small. They have increased the amount of officers in those units, and also simultaneously decreased the amount of USCIS officers actually interviewing and approving cases, which is why I suspect in the next few months, the processing time for a lot of these applications, especially the ones that need an interview, is going to get longer, right? They are, increasing the deportation ICE officers. They're really increasing the numbers there and reducing the amount of officers that are actually adjudicating cases, making decisions on cases, and making and scheduling those interviews. So even though their goal, right, their goal is to deport undocumented immigrants, they are also at the same time, without announcing it, because it doesn't look good for them. So without announcing it, they are also making it harder and taking longer for those going through the immigration system, filing for their family, going through what they're supposed to do, right? They say we want people to go through the legal immigration system. People that are going through that system are now having to wait longer because the administration is pulling officers away from that purpose and putting them towards deportation. So that is definitely going to end up making the whole process take months longer than it should. All right. Hi, Carl. If you filed waiver based on divorce, can you ask USCIS decision on your original jointly petition? It depends. Okay. So if you filed an I-751 based on a joint petition, so if you filed a joint petition and then you then got divorced, you would move forward with the divorce, right? I want to make sure that is clear. So even though you're filing jointly, your spouse can support, so your ex-spouse can support your petition, but just know the office is going to approve it based on the waiver, not on the marriage, because you're no longer married. Okay, so I've had this exact situation happen, so that's why I'm answering it that way. So I had this situation happen where they filed jointly and then they got divorced. We had to change it to a divorce waiver case, and then, right, and then the spouse, the ex-spouse, that's the U.S. citizen, went to the interview with my client, right? She went to the interview, answered questions about the relationship. The officer approved the case, right? So it's not unheard of, but they cannot approve it based on the marriage. They have to approve it based on the divorce because you are now divorced. So it'll be based on the divorce. However, your ex-spouse can support the application by either writing a statement, a declaration, or going to the interview. Because again, I've had that happen. If I keep getting denied from getting my US visa after it's been canceled for over 10 years, how do I get it back? I was never deported. My visa was canceled. So, hello, Malik. So it depends on why it was canceled. Okay. So you need to figure out why was the visa canceled and make sure you understand exactly why it was canceled, because that's what's going to make the difference. Okay, so you start with why it was canceled, and then figure out if the cancellation has like a time frame, because there's certain things that could happen. Um, yeah, so if they're not saying why it was canceled, you really, that's the key. You can't really keep reapplying unless you can't keep reapplying unless you know why it was canceled, so that you know exactly why you are if you need to include any documentation to overcome that cancellation, so that you make sure you have everything in there. But there's no way for me to really answer that question without knowing the reason it was canceled. And typically, yeah. So sometimes it's not. Okay, so Mickey's following up. I did get a lawyer. Okay, so sometimes it's not something in your background check. I just want to make that clear. So you may not have a criminal history. You may not have had like any previous immigration stuff. It may have nothing to do with you at all. Okay, so depending on the reason you're coming to the U.S., the officer may decide, do you really need a 10-year visa, right? Depending on your activities while you were in the US, that can also have an effect. If you've had family members that overstayed a visa after you got yours, that can also have an effect. So it really, there's so much that goes into that background checks doesn't really do it justice, right? Because I've seen people have their visa denied or canceled because a family member overstayed. And now the US government's like, if we let you go, you may overstay as well. So it doesn't even matter if it's you. Okay. Even when I go, thanks for the details. Even when I go, they keep saying I show no ties to my country, but they never look at my supporting documents. I have my father; he's a U.S. citizen. Okay, okay, um, you may have a better answer there now. Okay, so one, the offices don't actually have to look at your documents. They don't. I'm so sorry. It looks like, when you apply for a visiting visa to the US, you would assume that an office is going to look at all your documents. They don't have to. What they look at, what they must look at, right? What they must look at is your DS-160. What does your DS-160 say about your ties to your home country? Does it say you're married? Does it say you have children? Does it say you're working? Does it say how much you make? Right? That's where they start. If none of those things are on your DS-160, the officer can choose not to look at anything else you have. All right. So it really does start with that DS-160, and then the officer may decide to look at the paperwork. However, if your visa was canceled before, I'm telling you, reapplying over and over is not going to make a difference. And with a U.S. citizen parent, really not going to be beneficial to keep applying over and over without really truly understanding the ties component of it and building those ties, okay, making those ties visible in search. Okay. All right. Next question. Can you get deported even with a green card? Yes, absolutely yes. Okay. This is one of the hardest things for people to come to terms with, but yes, a green card holder can be deported if they have a criminal history, if they violated the terms of their green card, if they stayed outside of the US for more than a year, and they can show that they meant for the US to be their home. Yes. Nini, yes. Also, no criminal history. Can they deport you even with a green card when one wants to travel out of the country and return? So, no. So, those are two different things. So, if you are coming into the US after a trip, is the officer going to question you? Can the officer detain you? Yes. Can they deport you? That's different, right? That's a different. Can they detain you? Yes. Can they deport you? No. The only person that can take away your green card once you have it is an immigration judge, unless you give it up yourself. So that's why when I have conversations with permanent residents that are looking to travel, one of the main things I try to get through to them is that when you are coming back into the US, the officer may push you to sign some documents. Please do not sign anything. Okay? There's a form called an I-407. Once you sign that, you are giving up your green card and the officer can have you leave the US right away. So that wouldn't count as a deportation. So something like that. So even though it happened that you were at the airport and the person was turned back, that is not a deportation because you gave up your green card by signing that form. And I cannot tell you how many people have made this mistake and are calling me from the other side like, I don't know what happened. They just didn't let me in. Did you sign anything? Yes. Well, I think you gave up your green card, right? So it's really important that for permanent residents, as you're coming back into the US, you know your rights. Can they detain you? Absolutely. The US government has a lot of latitude when people are coming in and out of the US. Okay. The airport is not your, is not friendly. That's where the US has the most authority. Due process, who? Okay. Where's due process? You are at the airport. This is the height of national security. So the airport is not the place to make decisions without knowing what you're saying. So don't sign anything and make sure if you are being detained that you ask to speak to a family member or an attorney. If you're speaking to a family member, make sure that family member knows what attorney to call, right? And then make sure that you don't sign anything. Make sure that you are consistently asking to see a judge. Okay? Because only a judge can take away your green card. The officer, the CBP officer, cannot take away your green card. A judge can. Right? So the card itself, they may take the card from you. You are still a permanent resident. Even if they detain you, you are still a permanent resident. The card does not make you a permanent resident. The card gives you proof that you are a permanent resident. Okay? So can a green card holder that does not have a criminal history be deported? Yes. However, there's specific situations where that can happen. Okay? Especially if there's any fraud or misrepresentation, yes. However, if they're just going on a trip and coming back, unless you are in a situation where the Secretary of State specifically tells the immigration judge that these are the reasons you should be deported, unless you're in that specific situation, there has to be a reason, okay? But again, even in that situation, a judge has to order the deportation, okay? Right. So, what to expect, good or bad news, if no decision made during N400 interview after 5 months and USCIS still need 90 days when congressman contacted? It depends. Ooh. Can it be good or bad news? It can be good news. I have had situations where they say the exact same thing and the only reason they said that is because they misplaced the file, but they're not going to tell you that. Okay, I have seen them misplace a file. They're not going to tell you, oh, we're not going to do this right now because we misplaced the file. You contacting them, the congressman contacting them probably, triggers something, which is why they're saying the 90 days, but it may have nothing to do with you, right? On the other end, it could have everything to do with you if there's any background checks, if depending on how the interview went. That's where we usually start. Like, how did the interview go? Was there any questions that seemed like a gotcha? Like they were trying to dig for something. If there's any But typically with congressmen, when they send that inquiry, if it's a background check thing, they will let them know, oh, we're doing some background checks. We'll get back to them. But that's usually does the timeline doesn't usually determine how long what is good or bad news. The interview, how the interview went, is what's going to determine what is good or bad news. And the same thing goes for like national with adjustment of status. So green card interviews. If you haven't received any decision after a while, look at your interview. Okay, how did the interview go? Is there any questions that you got, you didn't answer well? Is there any places where the officer really focused on a specific topic? Because I've seen that happen as well. For my clients, when I go to their interview with them, I'm taking notes, comparing their answers in real time as they're answering the questions, so that right after the interview, I can do a quick like, hey, this is going to take a while because there were these inconsistencies in your answers, and the officer is most likely going to put you in the fraud unit for fraud investigation. Fraud investigations for green card applications, last time I checked, just the investigation itself, for an officer to be assigned to it, it's like a year. Okay, so that once it goes into that fraud unit, there's no timeline. They're not giving you a timeline because however long it takes them to find whatever they're looking for, that's how long it's going to take. Okay, Malik, interview over 12 years of marriage, is that normal? Absolutely. Okay. There's no So during the Biden administration, when they did a lot of interview waivers, I would have been like, probably not. They will probably approve it without an interview. With the Trump administration, where they're saying that all family-based cases are now going to have interviews, right? That's the norm now. So even though the marriage is 12 years old, you may have a quick interview, right? The officer may look at your forms, look at your supporting evidence of 12 years of life together, and just be like, yeah, okay, ask one or two questions and end the interview really quickly. So having an interview does not mean something is wrong with your case. It is normal to have an interview. Even under the Biden administration, it was normal to have an interview. You rejoice when you don't have to have an interview, but it is absolutely normal, regardless of how long you've been together. Hi, Abdul. There is any update for asylum seekers and work authorization as of now? So there's no asylum seekers can apply for work authorization. Okay, asylum seekers can apply for work authorization if they have met the 150-day or 180-day requirement. So once you apply for asylum, you have to wait at least 150 days before you can file the application for work authorization, and then you have to wait 180 days, right? So there's 150 days when you can apply, and then USCIS has to approve it after 180 days. So that's really the only thing there. There's nothing different that has happened for asylum seekers applying for a work authorization. Oh, great question. Do changing your address while your case is pending delay or deny your case? Changing your address does not get your case denied. You must change your address every single time you move while your case is pending. So important. If you do not change your address, that's a problem, right? That's a problem. But as long as you're changing your address, make sure that's not going to be a problem. You're not going to get penalized for changing your address. The only time it becomes a problem is, right? The only time it becomes a problem. Ready for this? If you move, but you were scheduled for an interview right before you moved. right? Right before you change your address with USCIS, they scheduled your interview for your old address. Your interview is going to be canceled because now the new place you move to has jurisdiction over your case. The old place you used to live no longer has jurisdiction unless it's still the same USCIS office jurisdiction. So that's really important. So if you are in Massachusetts and you go and move to Connecticut and your interview is scheduled for Massachusetts, you need to change your address because now Massachusetts no longer has jurisdiction over your case. That officer cannot approve or deny your case. They have to send it to where you live, which is Connecticut, because there's a USCIS field office in Connecticut. Now, if there's no USCIS field office in your state, which is not typical, but let's say there's no USCIS field office in your state, there's a USCIS field office that has jurisdiction over your state. Okay, there's one that has jurisdiction over your state, so that's where your case is going to be moved to. But that's really the only delay. In some cases, it can speed up your case if, let's say, you move from New York to a state that doesn't get a lot of green card applications. So now the officers have all this time. There's no backlog. So then they can go ahead and process your case faster because there's not a lot of people waiting for that interview. So it can delay if, let's say, you're moving from a place where you could get an interview in 6 months to a place you will need to wait like a year to a year and a half to get an interview. So that's where that difference comes in. Just making sure I didn't miss anything. Okay. What are the chances of getting detained at the interview? No active removal orders. So it depends on what case you have. Honestly, we are seeing people that have a removal order being detained, right? That have a removal order. So if you don't have a removal order, you are most likely not getting detained at your green card interview. All right. If you entered without inspection and you have an I-130 interview, please consult an attorney or have an attorney go with you to your interview because you may be detained. So that's even if you don't have a removal order. Okay. All right. Nini, is it important to have USCIS to clear up your record when they make a mistake on your file? Example, you attempted to re-enter the USA in the past due to USCIS error in denial that originally wasn't documented. USCIS error was originally denying adjustment of status, but calling to share it was their error, and that proven months later. The attempts to re-enter also got denied because of the USCIS. So if the adjustment of status was approved, it wouldn't really be a problem. So it would be in the records, right? So when an officer makes a decision, and then when they reverse the decision, it's typically in the records that happened. What I would suggest is getting a copy of your immigration file. So it's called a FOIA request, FOIA request with USCIS to see what's in their file about you. Depending on how they noted that in their file, it may be, redacted, right? But typically things like that where they denied it and then reversed that would be in your USCIS file. So you just want to take a look at that. Like I said, it's typically in the file, so you'll be able to look at it. But you would need to request a copy of the file. My dad came in the US in January. When can my mom file a green card for him through marriage? It depends if your mom is a U.S. citizen or not. So if your mom is not a U.S. citizen, she most likely would not be able to file for him. To get a green card, she can file an I-130, but not a green card application. If your mom is a U.S. citizen, however, the question becomes, did he have an intention of leaving and then something changed? What once he got here, right? Remember, when you come in with a visiting visa, you are saying that you are coming here for a visit only. And you disclose that you have family in the U.S. and what their status is, especially if an officer at the airport asks you about it. And if, as long as all the information provided was accurate and there's a legitimate reason for the change of mind about staying in the U.S., there's not really a timeline of how long they have to wait. Right. So if there's a legitimate reason for why they changed their mind, typically you can just apply. There's typically no timeline. Great question. What is the difference between initial interview and interview? Can the officer approve the I-485 and 601 on the spot? So initial interview means this is the first ever interview you're having with USCIS about that specific case. So let's say you're 485, that's the first interview that you're having with USCIS on your 485, right? So they always say initial interview. Okay, it's not saying that you're going to have additional interviews. It's just saying this is your first interview for this case. If the officer decides to schedule additional interviews, then it will say interview, right? Second interview, follow up, whatever. But it will always say initial interview for that very first interview. Can the officer approve the I-485 and the 601 on the spot? Yes. Will they? No. And I will tell you why. Most officers, especially with this administration, their decisions have to go through their supervisor. So they may say that they intend to approve it, right? They intend to recommend it for approval, right? Hear me out. They can say that, but the supervisor has the final say. So they can tell you, oh, we'll recommend your application for approval, congratulations, and then the supervisor will then approve it, and the case can actually be approved at that point. But can they like, oh, you're approved? Unless it's like a higher up officer that does not need supervisor's approval, no. But they can give you hints of what they plan on doing. Again, the way the interview goes will tell you a lot about what decision is going to be made. Can someone get married in another country and do same in the USA with same spouse and get both marriage certificates? Which one to submit to USCIS? So, great question. It depends. So some countries, they have traditional marriages. And sometimes you can get a certificate for that traditional marriage. And sometimes there's no certificate, right? Sometimes there just isn't. And then people will have their registry wedding, which is like the typical what you would think a wedding is. So when you can you do both? So I've had people do a traditional marriage in their home country, and then when they come to the US, they do like the let's go get a marriage certificate, do the whole dress and everything, right? That is fine. The question is, was that traditional marriage a legal marriage? Okay. That's where the question starts. Was it a legal marriage? If it was a legal marriage, if it counts as a marriage where you're from, without anything else. So if you didn't go and register it. So some countries, if you do the ceremony but you don't register it, it's not considered a legal marriage. And then in other countries, just the ceremony alone is a legal marriage. So it really just depends on the country. If it counts as a legal marriage, you can use the first one and not the second one. Oh, if they're all legal marriages, you can. So we've included both before, but the legal marriage is typically the first one, right? Unless you got a divorce, but the legal marriage is the first legal marriage. But we typically include both of them and explain why there's two. Yeah, but it really depends on the details, right? It really depends on the details. But the first legal marriage is the legal marriage. The only things that I will warn people on about getting married and then coming to the US and getting married again is if your visa, right, when you apply for your visa, did you disclose that marriage? Does that marriage affect your visa type? So for example, if the person came in on a K1 visa, but before they came in on that K1 visa, you did the legal marriage over there, that K1 visa is no longer valid. So that's the only time it would be like a problem. Okay. But in general, if they came in with a visa that did not have anything to do with the marriage and they disclosed the marriage on the visa application, then it shouldn't be a problem. But you just have to be very careful with the, like this is one of the situations where the details really matter a lot, and the timeline matters too. Harry, I would like to know, what is the case that you have to send a letter about if your family is endangered to another country? Not sure what you mean by that. So do you want to give me more detail? Like schedule a strategy session? Because I'm not really clear. Okay. So I see. Maybe you're talking about an expedite request. So your case is a year and 5 months right now, and what takes so long for USCIS to send it to MVC? It depends if USCIS has already approved the I-130. So if USCIS has not approved the I-130, they can't send it to the MVC. Okay. So if the I-130 is still pending, they cannot send it to the MVC. If the I-130 is already approved and the case is not sent to the MVC automatically, you need to look at your I-130 application and make sure that you actually checked off that the person will be applying for the visa from outside of the US. You will be surprised how many people make that mistake on their application and just not check off that box that says that the person will be applying from outside of the US. So if the I-130 is approved and that box is not checked saying that the person will apply from outside of the US, USCIS may not send that case to the National Visa Center because they don't know if the person will actually be applying for a visa from outside of the US or if they're physically in the US and will be applying for a green card in the US. So that's two ways to answer that. And then when the case is at the MVC, if it's taking time, you can, again, do an expedite request. You can do an expedite request for an I-130, and you can do an expedite request for an interview at the embassy. But just remember, in order to do an expedite request for your embassy interview, you must have completed all the documentation required by the National Visa Center. So if you have not completed all of that documentation and the National Visa Center has not sent you an email telling you that they have all the document they need, that you are documentarily qualified, they will not even look at your expedite request. So, and also make sure if you're sending an expedite request that you are including evidence with it, right? Documentation to back up what you're saying. So I hope that answers your question, Harry. All right, guys. Thank you all so much for joining me. Like I said, it's been 100 days of the Trump administration. Feels like 100 years with all the stuff that's hitting us, but we're still here. We're still working towards this, and helping people get their green cards, get their citizenship, get their visas. So that's really the best part of my job, is giving my clients good news of like, hey, you got your work permit, you got your green card. All of those things are the best part of my job. Dealing with the administration and their ever-changing policies, not so great. Let's see. Question. Is it an issue if after I-130 approved, someone came in USA and get his green card? After notice that after that, they noticed on the DS-260 some mistakes was made by the petitioner while filling it out. It could be, depending on what the mistake was, right? If the mistake is material, meaning if it would have made the officer make a different decision, right? Either deny the case or ask more questions or require more documentation or evidence, then yes, it would be a problem, right? So it's the difference between, let me just give a quick example. It's the difference between saying that someone doesn't have any children, right? Someone, the beneficiary has 0 children, and then the truth being that, oh no, they have a child, and that child was born during the marriage, but by someone else, right? So it wasn't a child that's the couple's child, even though the child was born during the marriage. That is material, because that would have led the officer to ask more questions and question the bona fides of the marriage. Because if you're having children outside of your marriage, is this marriage real or not, right? So in that situation, that would be the case. However, if it's a child that was born during the marriage and it wouldn't have made a difference whether the officer knew about the child or not, then in that case, no, it wouldn't be a problem. Can you get detained because of old records? It depends on what those old records are, and if they make the person deportable, then yes. But it depends on the records. How long does a VAWA RFE take? My friend sent reply to RFE in December. She hasn't received anything yet. So you don't receive anything after a VAWA RFE. So it's a request for evidence. They're asking you for more evidence. That does not mean that they are making a decision right away or whatever. They're just trying to have a complete file for you. So when you send in your response to a request for evidence, they put it in your file and it just goes through the normal processing time. They're not going to send you anything saying, we received your response to the request for evidence. If you want to check that, you can do the case status update. You can call USCIS. You can email the VAWA unit. But as far as like them sending you something in the mail saying that they received your request, your response to the request for evidence, you are not going to get it. Okay? Just know that. Even if it's not a VAWA case. Anytime you send a request for evidence, you send your response to a request for evidence, you are not going to get a letter back from USCIS saying, thank you for sending us your response. You're not getting it. Can someone without criminal records travel with an advanced parole? Yes. Right? Can they travel? Yes. Should they travel? So can they travel? Yes. Should they travel? Completely different case, right? Completely different question. If your question is should they travel, no. I am even advising some of my clients not to travel, even though they have a green card. So it really depends on your particular situation. If the advanced parole is based on if the advanced parole is based on a green card application that you have pending, talk to your immigration lawyer. Is it an emergency? Do you really need to travel right now? If, let's say, for example, you have TPS or you have DACA and you have advanced parole and you're trying to leave and come back on that advanced parole so that you have a legal entry so that you can then apply for a green card, that may be a different, you know, calculus that you need to do with your lawyer to determine if it's worth the risk of potentially being detained or not. So it is not like a straight yes or no, you should or shouldn't travel. It depends on your particular situation and what the consequences can be, okay? And if it's worth it or not. So typically, if it is based on, I will tell you this, typically if it's based on, if you have advanced parole based on a green card application that's pending, you're an immediate relative of a US citizen, unless it's an absolute emergency and you're not just going on vacation, you're not going anywhere. At least that would be my advice, right? So if it's not an absolute emergency, and you're not trying to use that to get yourself a legal entry, we're not having deeper conversations. My answer would just be like, stay here. But if there's deeper conversations that need to happen because there's a purpose to the advanced parole beyond just visiting, family and friends, then we would have that. If you get approved with old criminal records, no new charges, can you travel with no problems? It depends. You want to make sure that those old charges do not make you deportable. So those are two different things. So it may not make you inadmissible, but the question is, does it make you deportable? Because those two things need to be kind of evaluated before you make that decision. Again, there's deeper conversations that need to take place before you travel, especially if you have a criminal history, especially if you have a pending application. You really want to have that conversation. But as long as the criminal charge doesn't make you inadmissible or deportable, you are typically okay, right? But you really do want to take a look at all of that before you make the decision. Okay. All right, guys, I do have to jump off, but thank you all so much for joining me. If you're still here, please go ahead and like this video. It tells people that you enjoy what you're watching. And also, if you would like a detailed consultation or a strategy session, please go to my website, lilylegal.com/contact us. It's on the bottom banner right now, so feel free to do that. Go on the website, select contact us, and you can actually pick a date and time that works best for you for us to chat. Okay, Zach, I'm gonna give you the last question. Okay, last question, and then I'm out. Ask your question. Okay, so best way to contact me if someone is detained, you want to call the main call our number, and if it's not me that picks up, let them know it's an emergency, and right, and that you're detained. Those two things. Not just it's an emergency, but that the person is detained, they will transfer the call to my personal cell phone immediately. And especially if it's after hours or on weekends. So if it's something that's happening on a weekend or after 5 o'clock, If it's not between 9 and 5, Monday through Friday, or if it's a weekend, you want to call the main number and, right, call the number and say that it's an emergency and you're detained. It will be transferred to my personal line, and then we can figure it out. Another thing that I would say is you may only have one call. When you are detained, you may only get one phone call. So you want to make sure that you call someone, right? That's part of the preparedness thing that I talked about last year and earlier this year. Is you want to have someone that you can call that has all your information and knows which lawyer to call for you. Okay, so that's really important because you may only get that one phone call. So make sure that you have that person that you're calling that has all the information, that can call the attorney on your behalf and give them all that information. So I wouldn't even suggest me being your first call. I would suggest having that person that can get me the documents, that can get all of that, because once I hang up the call with you, who do I contact, right? So it's really important to do that. First, have that contact person. Make sure they have your copies of your documentation. They know your whole travel history and all of that, so that when they do call us and say the person is detained, this is where they have all that information ready to go for us, and we're able to have a deeper, a longer conversation. Because again, when you're calling from the airport, or when you're detained, you may not have more than one phone call, and you may not have a long time in that phone call to explain. So, and you may not want to be explaining that in front of an officer either. So super important. um Okay, fine. One last question. I would like to know, if a baby is born in another country and the father is a U.S. citizen, the baby can still be a U.S. citizen through the father's citizenship? Yes, that is possible. It is called a CRBA. I have a whole video on my channel where I break down the steps to a CRBA, what that is, how to get it for your child. So yes, a child born outside of the US to a US citizen parent may already be a US citizen, but they will need proof of that citizenship. And you will need to do a CRBA, consular report of birth abroad, for them to have proof of their citizenship and also to be able to get a US passport. All right, guys. Thank you so much for joining me. I will see you next week. And we'll probably do more Q&As as always. I give you information at the beginning, and then the rest is just Q&A. So thank you all so much for joining me. Like this video, share this video, and I will see you next week. Oh, and if you don't know who I am by now, I am attorney Lilian. I'm a US-based immigration lawyer, and I help my clients get green cards and citizenships for themselves and their families using the US immigration system, whatever it looks like at the moment. All right, bye guys.